This is Werner Sabo. I'm a construction attorney and architect in Chicago. I'm also an arbitrator and mediator. In these videos, I discuss arbitration and mediation topics. So what are the differences between arbitration and mediation? And what about litigation? Where does that fit in? So I think we're all familiar with litigation, where you have a judge, possibly a jury, and they hear evidence and decide your case. That can take years sometimes, and there's all kinds of appeals that might be involved. It gets quite expensive. So in certain cases, especially in construction cases where there are many technical issues that a jury probably wouldn't understand very well, and most judges don't understand either, there are other ways to resolve disputes. And the principal ways to resolve disputes, particularly in construction matters, are mediation and arbitration. They're two different procedures, and you can use both of those processes. So mediation is probably the first thing you would try if you have a dispute in a construction situation and the parties can't agree. So typically you sit down, you try to work out what the issues are, and you reach an impasse. You can't get anywhere. That's where a mediator comes in. So a mediator is normally somebody who is very familiar with the construction process. Often it's an attorney with many years of experience in the area. And sometimes it's a judge and so on. But you have a neutral party, an outside party, look at the dispute, talk to the parties, and try to facilitate a settlement. Now, a successful mediation results in a settlement agreement that's enforceable, and the dispute ends then and there. So obviously, if you can resolve a dispute early on, then you've saved a lot of money, a lot of time, and a lot of aggravation. What if you can't resolve the dispute through mediation? Then you have generally one of two options. If you don't have an agreement to arbitrate, then you go to court. You go into the litigation process, which, as I mentioned, can last a very long time and can be very expensive. If your contract, like many of the form contracts used in construction, has a provision for arbitration, then instead of going into court, you obtain an arbitrator, usually through an organization such as the American Arbitration Association and Disputes, or one of the other organizations that's around. And you select the arbitrator from a list that's given to you, or perhaps the attorneys can agree on somebody that they know who they're very confident in that will be fair. But generally you go to an organization such as the American Arbitration Association, you file the paperwork, they give you a list of potential arbitrators with biographies, and the parties then will select one of those arbitrators. If it's a very large case, you will have a panel of 3 arbitrators. So the arbitrators then, the arbitrator in most cases, is going to be like a judge who hears the evidence and issues an award at the end of this process, much like a judge would issue a findings of fact, issue a final judgment that's enforceable. Now, the advantage of arbitration is you can tailor this arbitration, and you can tailor it in your agreement up front, or you can tailor it during the process. And often the arbitrator will help the parties, the attorneys involved, to modify the agreement or to agree on how the arbitration is to proceed. So there are very many advantages of arbitration over court. Again, the arbitrator is typically going to be somebody who knows a lot about construction, unlike a judge or a jury. The rules of evidence in most cases are not applied, so that tremendously speeds up the hearings. And the arbitrator is allowed to ask questions and basically move this process along so that instead of a number of years that you might find in court, it's down to usually months where you go from the beginning of the process to the end of the process. The other advantage of arbitration is it's final. It's very difficult to appeal an arbitration award, unlike in court where anybody that's dissatisfied with the judge's findings or the jury's findings can take it up to the appellate court and add another year or more to the process and possibly another level of appeal beyond that. So arbitration is normally a faster and much cheaper process than litigation. Mediation, on the other hand, is a different type of process that's designed to lead to a settlement. Mediation is voluntary. Now, you can have a mediation going even into the arbitration or litigation process. So if you have a complicated case, perhaps the mediation doesn't wind up with a settlement, it doesn't mean you can't keep that mediation going into the arbitration process. So, and I've had cases where the parties come maybe a little bit closer than they started out in the mediation, but it doesn't seem like they're going to have a settlement. So either litigation or arbitration starts and things change. The costs pile up, new information comes out, and it then sometimes makes sense to come back to mediation, and you still settle the case, and you settle it well before a hearing or a trial, which saves the parties a lot of money. So the earlier you can settle a case, the more money that will be saved for the clients. Another good reason for mediation, especially in the construction arena, is that you often have parties that deal with each other on a repeat basis. A general contractor hires the same subcontractor over and over again. An owner might hire that general contractor for a series of projects. If a dispute arises and it goes all the way through an arbitration or all the way through court, you're probably going to have very bad feelings among the parties. Whereas if you can mediate that and reach a settlement where everybody agrees on the outcome, it's usually possible to salvage that relationship. So I think that's a very important reason for parties in a construction case to really try to mediate that and resolve the issue before it goes any further. So to summarize, mediation is a process where the parties agree to mediate, they select a mediator, it's voluntary. Parties can always walk out of the mediation if it's not going the way they want it to. And so any settlement is by agreement. Arbitration and litigation, on the other hand, there's no longer agreement. The outcome is imposed on you, either by an arbitrator or by a judge or a jury. So mediation is always the best way to go. If it's not successful, I would suggest in the construction arena, arbitration is the backup for that, the next step, the next best alternative. The last alternative in most cases is litigation, but it depends on your contract. If your contract has an arbitration provision, then you must arbitrate unless both parties agree to waive it. If you have nothing, if it's a handshake deal, it's usually very difficult to get the parties to agree to arbitrate. It's often, even in the absence of any kind of decent contract, it's often fairly easy to get the parties to mediate a dispute if the attorneys are reasonably sophisticated and knowledgeable about construction. So mediation is more possible than arbitration if you don't have an agreement that says you must arbitrate. So 3 different processes to resolve disputes, and you really need an attorney if you are involved in a dispute that is familiar with these various alternative approaches, the pros and cons, and there are cons on each side of these things. So take a look at that, and hopefully your case will be resolved earlier rather than later.